5 minutes have been done, my lord. My lord, on the contention that the applicants are in lawful custody. My lord, we are really disturbed by the justification given by the senior state attorney here, reading it too much into the Supreme Court decision. Is suggesting that by ordering a transfer of the files, by extension the remand warrant was extended. That is, if I got him well, correct. That is an absurdity, my lord. He reached a point of suggesting that if court held otherwise, it would amount to contempt of court. That if this honorable court held otherwise, that it would amount to contempt of court. We take exception to that, my lord, on the following grounds. One, my lord, the Supreme Court was categorical in its directions. And if they wished in any way to save any order of the defunct General Court Martial, they should have said so. If in any way they deemed it necessary to keep the applicants on remand pending transfer of their files, they should have expressly stated so. It's nowhere stated in the orders. My lord, the Supreme Court went ahead even to give structural interdicts in regards to areas of amendment to guide the Parliament. If they could go out of their way to guide the Parliament, if they are to come up with a new legislation, the parameters, the principles, how about on the issue of remand, if indeed they wanted the applicants to remain on remand pending the transfer? That is one. Two, yes. Yes. No, that is for the legislative process. There were structural interdicts. But if for declarations, my lord, they have to be contextualized within the existing constitutional order. Now, for the transfer of charges and the files, they have to be put within the context of Article 24, rather Article 23 of the Constitution. And I will read it. Article 23, unfortunately, I'm being bombarded. Article 23, 4B, the 48-hour rule. That anybody whose rights are whose liberty is restrained shall, if not earlier released, be brought to court as soon as possible, but in any case not later than 48 hours from the time of his arrest. My lord, the Supreme Court decision should be read in that context. That actually the Supreme Court did not purport to overthrow the Constitution. They couldn't do so. So if the state wished to continue with the prosecution of those cases that hitherto were being handled by the General Court Martial, the time frame is set by the Constitution, 48 hours. And in lawful custody, I don't want to give them the advisory, but if we were to go there, what I would do immediately, you would get them from prison within the 48 hours, take them to police, in police custody, because you will then be breaching section 37 of the Prisons Act to keep them on remand without a remand warrant. If I may ask my lord, the prosecutor, I mean the state attorney who is justifying the detention, the court. Okay, let me give the answer here, my lord. Okay, let me frame it as a question, my lord. Are the applicants right now on remand? Are they on remand? Pending what charges? If they are in custody, pending fresh charges being preferred against them. Yes. Right now. If so, exactly. Yes, what charges are they facing if they are on remand? And if I may add another question to that. If indeed they are awaiting transfer of their cases or charges for that matter, in the affidavit here they are indicating those charges, those matters are being handled by the DPP. And my land colleagues here have cited Article 120 of the Constitution, which bars the DPP from sanctioning files before the General Court Martial. Has the DPP got anything to do with those charges, which were hitherto being handled by the General Court Martial in the context of Article 120? Even if they were to be transferred, has the DPP got anything? And finally, still on that question, my lord, when you read the affidavit of Kkomera, the Attorney General is simply saying that he wrote a letter to the DPP and the Minister of Defense. He is not indicating any action taken. Yes. No. Most obliged, my lord. Does it in any way address that? And in any case, my lord, in section 10, the Attorney General Kkomera says the Attorney General's chambers forwarded the Chief Justice letter to Ministry of Defense and the DPP advising that the files be forwarded to the principal judge. The Attorney General simply states that they acted as a conveyor belt. They received the letter from the principal judge, forwarded it to. I wanted to advance an argument in this because this is my construction of my understanding of this. Correct. No. My lord. Legally, I wanted to advance an argument, my lord. Yes, because within the meaning of Article 120, the office of the DPP is independent of the Attorney General. Yes? Article 120, clause 6.
Is it legal in light of Article 120?
In the independence of the DPP. No, not asking, actually, it's their argument I'm advancing. And I want to conclude it by indicating to you, there is nothing on record that shows that the DPP has taken any action. There is nothing. There is no record whatsoever that the DPP has taken any action under Article 120 in their evidence. That is one. Two, yes. No, my lord, the DPP had 48 hours within which to do that. Yes. My lord, the application for habeas corpus is now being heard and there is no charge by the DPP. And this is our contention. With all due respect, my lord, I wouldn't want to venture into a matter which is in abstract, my lord. Most obliged, my lord. Related to that, there is nothing on record here regarding any action being taken by the Ministry of Defense in response to paragraph 10, that the conveyor belt, that is the Attorney General, after relaying the communication from the Chief Justice, it's metaphorical, my lord. Most obliged. Because the Attorney General's chambers forwarded the Chief Justice's letter to the Ministry of Defense and the DPP as a courier. Now, not a conveyor belt. They acted as a courier. Yes. Okay, let me say, they relayed. Most obliged, my lord.